All right. And we're going to move on to the main event here. So I'm going to hand this on over to Shannon. Lots of great information here. Looking forward to a lot of great discussion as well. Those of you that are joining us online, if you put in anything into the comments, the chat there, we're monitoring that as well. So we'll make sure we can ask some of those questions here as well, live.
Gone? All right. So we'll be honest here. Nate's a little under the weather, and so we had to pivot very quickly yesterday because he was going to be doing his presentation, and I'm seeing Jody's not here, so here we go. I'm on my own. We'll see how this goes.
She is a wealth of information. It'll be good.
I mean, I do have a lot to talk about, but I was hoping to have a little support, but that's okay. Do you want to go next slide into the names? Okay, so something I've talked about a lot, you guys, is names. And I feel like a broken record. I've said this a million times, but the names are critical. And there are so many transactions that we're seeing that are not signed properly or have the owner's name on the contract properly. And that becomes an unenforceable contract, you guys. That's really critical that you get that right and that you're checking those deeds. And if Jody were here, I know she would like to pipe in and say, don't trust Monsoon all the time. Don't just take that name off the top of that tax record. Go to the deeds. Even better, go to the county and look up those deeds and see who's on title. Because you'd be surprised how many people will pop up that you maybe don't realize or weren't aware of how they took title. An unfortunate side piece to our world right now is there have been a lot of people pass away. There have been a lot of deaths, and unfortunately in the last couple of years, and with trusts and all these different things, there are family members who are coming out of the woodwork who might have been on property, that kind of thing, or had rights to it, or, you know, those kind of things. And I'm getting those challenges hit my desk when we're in escrow and everybody figures it out. And then there's going to be a delay to go through probate or whatever the situation is. And all of a sudden that creates issues for maybe the person who was moving on to another property in another transaction, and you get the idea. So just really pay attention to that. And if you're not sure, go to your title company first, have them check on the property first to make sure you've got the right people signing and signing properly. So this document is that signature blocks page that we have for reference for you guys in working docs of SkySlope. And if someone has a trust or a personal representative or they're an LLC, these are the way they need to sign and how it needs to show for ownership on the contract. I know one of the challenges is space with the autofill and the technology side of the contracts. So what you need to know is that the owner and seller or buyer name needs to be the name of the actual entity or trust or whatever it is. And then the signature is just whoever is allowed to sign for that as trustee, as personal rep, as manager member, whatever they are. So you have to change that signature block. Does that make sense? And that's where we see a lot of the challenges because you autofill it, you put it in and autofill it, and it's not coming out and being signed properly when it's going through those electronic signatures. So just be careful of that. This is for reference for you guys. Jody also, and I'm going to be emailing these to you guys in the broker blast this week. So you have these in your email. You can save them somewhere. But this one talks about what you should do if there's a power of attorney to confirm that power of attorney works for the property. We ran into a transaction recently where the seller had a power of attorney recorded, or I think it was a power of attorney recorded in another state. It wasn't valid in Arizona, was what was discovered during escrow. So those kind of things are the things you want to have checked by title ahead of time so you're not dealing with it at the last minute and having issues. But this kind of gives you what happens if it's a power of attorney, a trust. I think on the next page is the business entities, LLCs, that sort of thing, and how to handle those. So I just thought this was a really nice reference piece, and I appreciated Jody providing it. Did you have a question, Jim? Okay. Potentially. So what I've heard, and I thank goodness we haven't actually seen this, but what I'm hearing is happening is, we're in a competitive market and people start looking for loopholes when they want to change their mind on something. And what they're doing is they're going to an attorney to look for those loopholes, and that's what they're finding. And then they're saying, you don't even have a contract. Don't worry about it. Walk away. And there's not a whole lot from what I'm hearing they can do. So right. Oh, gotcha. So the question Jim just had was that if we're on the opposite side, so maybe it's we're representing buyer, but seller has a trust or an LLC, or should we be asking for those documents? I don't necessarily think so, but I would maybe confirm with title just to get a, hey, do you have what you need? Are we good? Does anybody else need to sign that? Just confirm with them, maybe might be the way to go, to have them double check and watch those title reports real closely and make sure that when you're getting those, that if anything pops up that's different, that's being addressed as needed to, as well. But that's a tough one because one of them that we ran into was on the seller side and we were on the buy side, and it created it was a huge issue because they had sold their house. The buyer had nowhere to go. Seller needed another 3 weeks to deal with the legal issue of getting it cleaned up, and you can see where those challenges come up. So, yeah, and then if there's a deceased owner, if one party is deceased, or and again, how they hold title is very important. Whether it's community property, all these different ways. It's really critical that even if you don't know all the nuances of these things, that you confirm with title, so that they confirm who needs to be signing and how, and what documents are needed. Does that make sense? I wish Jody was here because I think she'd probably have a lot more input on some of this, but I just wanted to share this. I thought this was a great reference piece. I'm old, guys. I need paper. A couple of random things before we go into this homestead portion of this. COVID. Unfortunately, we're all seeing the little spike we're going through, and I've already had, I believe, 3 calls this week where COVID is affecting a transaction, whether it be because they can't get in for showings or inspections, or closing delay because someone is quarantined. So I would just encourage you that you might want to think about the COVID addendum again, or at least be having those conversations again, reminding clients what could happen if someone gets quarantined, and addressing that up front, so not everybody's upset at the end when they can't close on time because they can't get in and do a walkthrough or whatever the situation is, or someone can't sign because they're quarantined, that sort of thing. So just as a reminder, it's an unfortunate reality that hopefully this passes quickly, this little spike we're having, but for now, you might want to readdress that with your clients. And appraisals. I'm seeing a lot of appraisals come in low. I don't know if anybody else is experiencing that, but I've gotten several calls in the last 2 weeks for that, and large amounts. A $500,000 house, and we've seen 3 of them that were between 70 and 90 low. So you're not talking $1 million house where that, relative amounts, that sort of thing. So just something to be aware of. Something to consider on that. We've had a situation recently where, hopefully Nate's okay with me sharing this on his team, but they had a transaction where the appraisal came in low. Buyer had waived their appraisal contingency, and then determined that they still didn't want to move forward because they'd rather lose the $10,000 earnest money than they would the $60,000 of equity, kind of a thing. So, something to consider with the market we're in. I can see that becoming more of an issue here lately. So, and then the last thing is going to Homestead, is working in your area of expertise. I get a lot of requests for doing a transaction in Pine, or I just want to buy this, my friend wants to buy this one place. Can I help them in out of area, Prescott, Flagstaff, all the places everybody's trying to buy second properties or VRBO properties, that sort of thing. And I'm just going to share with you, I don't want to be difficult about this, but I get way too many transactions that become a challenge because someone doesn't know the nuances of that market. They don't know the comps. They don't know the neighborhoods. They don't know how the utilities run. They don't understand certain things about those areas that become critical, and it becomes a challenge. Commercial, we get a lot of people that want to sell it's just a piece of land. Well, there is a lot that goes into that on the commercial side. There's a lot of different inspections and environmental and all these other things and zoning and what they can build and not. And if you are not intimately familiar with that, just give it to someone who is. We've got Roberta, we've got Tom Witt doing commercial, we've got, people in Flagstaff, we've got people in Prescott. So if you need those areas, we likely have someone, and I would just really, really encourage you to let someone else handle that. It's just not worth it. Stay in your lane, what you know, and be good at what you do in that area. So that's just my little speech on that. So homestead exemptions. So is everybody aware that this changed January 1st? Everybody knows the gist. So I'm going to be honest, I'm not going to say I stole it, but I'm going to use this presentation because it has some really great examples. And I felt Jody provided this when we were kind of talking about this part from the title side. And I just thought it has the best examples to break it down for you that might help.
And as you can see, there's very clear attribution there. Thank you, Gust and Rosenfeld.
Yes, thank you, Mike. So we're going to go through this really quick. I'm going to use their presentation just because I think it's just the best, and they did a great job of summarizing this. So we're going to go through why the change, highlights, scenarios, notice requirements, priorities, and questions. We can probably go through these pretty quick. In 2018, what started this conversation or why this legislation changed, it stemmed from a lawsuit where there was a recorded judgment. It didn't get paid, or it didn't get paid. It was missed. And the judgment creditor then came back and tried to judicially foreclose on the new owner. So that's what caused this. So as you know, in the historical side of this, the law basically says that no lien or judgment shall be claimed against a homesteaded property. Keep in mind, I want to clarify because we just talked about names. The statute that talks about homestead exemptions is for a person. It doesn't say entity, meaning a trust, an LLC. They don't have a homestead exemption. Those properties all of a sudden lose that unless you're an actual person. So keep that in mind when you're moving forward and looking at some of these and whether something like this applies, because that exemption goes away if it's an entity or a trust or they have ownership in a different way. So just as a side note. This is just background. The biggest change January 1st is that the homestead exemption increased. Two biggest things. Increased to $250 from $150, which is good. A little more protection, especially with our prices increasing. And then that a judgment lien can now be attached to the property, to real property. So that's big. So, we had a situation about a month and a half ago where a seller had co-signed for a family member on student loans, and they had defaulted, and it became a $30,000 judgment against them. And all of a sudden it shows up. They weren't, they had enough equity that Homestead didn't apply in that case. So they had to pay that. It was a surprise to them. So those kind of things do happen. Credit card judgments, these kind of things that they come up more than you realize. So now that they're going to be attached to properties, it's something you need to be having that conversation with your sellers right up front in your listings and saying, is there any judgment potentially that's coming up, or have title look for that kind of thing. So because it's going to be more in the conversation. It also affects refinances. So basically means that for no cash out refinance, title company may record a subordination of judgment lien, and for judgment debtor may not receive any refinance cash until that's satisfied. So it's paid if they're doing a cash out. So a couple scenarios, because there is one little nuance in this that says there's this kind of 80% rule. So it's all based on the equity in the property is what the seller has. So for these examples, for the 80%, if they have 80% of the 250, so if they have equity between 200 and 250,000, the title company, if a judgment comes up, has to send that creditor a notice. And I believe they have, I don't know if it's on here, but I believe it's 20 days or 21 days to get that back. So again, something to be aware of is if that's going to be a factor, you need to to factor that into your close dates and make sure there's enough time to get those notices properly filed and get them back in that amount of time. So you're not delaying closing. Can you back up one more? Sorry. So if you can see the example, and this is the part I felt like it kind of hammered home how this is going to work. If the sales price of the home is $400, the deed of trust, so their mortgage is over $200, they have $170 in equity after their reasonable closing costs and real estate agent fees. They have $170,000 in equity. It's, where am I at? Less than $2,200, $250. So they do not have to pay that judgment because it's protected. Again, if it's a person, it's protected. And then, right? Thank you. If it's between 200 and 250, this is where that same scenario, now they have to send, it is 20 days. They have to send, that title company has to send that notice, and then they have the right to the judgment creditor to either release it or say no, in which case then the seller or the debtor can contest that, but they'd have to do it through a lawsuit to clear that lien. Does that make sense? And I'll go over some thoughts and questions because I've got a bunch. Scenario 3 is if they have more than $250,000 in equity, that judgment lien has to be paid, is the short version. So no matter what, and it attaches. In this case, the difference was what happens if the judgment lien takes that equity less than the 250. Doesn't matter. If the original equity minus reasonable costs and fees is 250 or plus, then that judgment lien has to be paid regardless. Does that make sense? Refinance, we talked a little bit about this. Same rules apply essentially, just depending on if they're taking cash out or not, if that matters. This is if they take the cash out. Is everybody seeing this okay? I'm following. And again, if they're taking that cash out and they have more than the 200 or 250. This is for the notices. There's a lot of, so the notices, we actually have copies from title. We got those just to kind of see how they were going to do it. But it's basically all this information that they have to fill out. It has to be included properly, sent out to that judgment creditor, and then getting that back. All the requirements. Yes. Because this is all just the nuances and the details of this. So this is how it will work for those, because we're kind of in that, this law just went into effect, or the change just went into effect. So for anything recorded prior to, so December 31st of 21 and back, will not have, the new law will not apply, but anything recorded January 1 forward will. So for any of your closings. And just the thank you. So a couple things that I have thought about, or questions that I've had, is that the reasonable fees and the agent costs, when you're determining that equity, I'm not entirely clear what that means. I know that what in my mind that means is that if you have a seller that you're trying to reduce their equity position so that they don't have, for example, if you were trying to be sneaky, and you're trying to reduce that position so that they don't have to pay a judgment lien, if you typically charge X for your agent fee, and this time you're charging XYZ and every other letter of the alphabet on top of that, that's going to be a red flag. And if it's questioned, you're going to have to show, why was this transaction different than the other 30 you did? And why did you charge differently? So reasonable means being consistent, being what you would normally do for any other client, that sort of thing. Reasonable title fees, those kind of things. You're not going to, you can't puff those numbers, if you will. And if it's questioned, again, you're going to have to show, why is that number different than what's normal, or what you've done for the last however many transactions, if that makes sense. Because I can see that where people are going to try to play things. That's the way, they try to get out of having to pay these kind of things. But again, some of those kind of pieces are kind of yet to be seen. This is so new that we're going to see how this goes. Now, Jody explained to me that their legal counsel, ironically, the timing of this didn't quite line up, but they're actually meeting at 10 o'clock today, which might be why she's not here, to do training for all the title side on this. The next month, her legal counsel is going to be in town, has offered to teach us a class and go even deeper on all of this stuff. So I would encourage you guys, if you have questions about that, and my disclaimer is, I don't know that we know everything yet and we entirely understand all of this, but I wanted to give you an overview so that you can be having that conversation with your seller right up front as you're on listing appointments to see if any of this even potentially applies, given the scenarios. Does that make sense? And anybody have questions on any of that? Right. Do you agree? I don't know if anybody's taken anything else. Go ahead. Do you guys agree, though, that I felt like that presentation, just because the way they laid it out, I thought was really helpful. In my mind, it just helped clarify some of the pieces I wasn't entirely sure about. So we'll make sure everybody gets a copy of that because I think it's really helpful.
Yeah, and when we were chatting before, I think what at least I've noticed about this is if you spend a little time actually looking at those bullet points, and then suddenly your brain applies it to something that you had last year, and then all of a sudden it's very real, right? And you go a little bit deeper. So as Shannon mentioned, that stuff will be shared out as well, the Broker Blast stuff tomorrow. So take a look and actually, read through those bullet points. And if you do have a specific scenario, specific questions, all that, please make sure you share those through. And as Shannon mentioned, we will be going deeper on this. It's going to, necessitate us going deeper on some of these things. But again, it's still kind of evolving with some of the, maybe not interpretation, but again, the scenarios that are showing up and whether or not they actually apply, that sort of stuff. So, it's still pretty new. It's been in effect 5 days here, but right. Yeah.
And the rumors I'm hearing in some of the meetings I've been in, with other brokers and other folks, is that this is likely not the final version of these changes, that there are some parts that are a little bit too vague and that they're going to be redefining those things in upcoming legislative sessions this year. So we may see a change to this next year, kind of a thing, or maybe more defined pieces of it next year is what I'm hearing, because there's a lot of questions that have come out of it already. One other thing, can I just mention one more thing?
Absolutely.
Well, I'm on a soapbox. On the names and things, I know everybody gets frustrated with us when we're reviewing files and we're making notes that these initials were missed or that a correction needs to be made and everybody needs to initial those changes. I want you to kind of put it in perspective, though, of think about if you've ever bought a house yourself or signed for something with a title company or a lender. How careful are they? If you miss an initial or you don't sign properly, they make you redo it. They don't let that slide. They don't get to leave a blank. They don't get to have the wrong person sign. They're incredibly careful. If you've ever been through that process, I'm assuming you have. We should be equally as careful. And I hope that puts it in perspective of there's no reason we should be handling this as seriously as they do, because there's a reason they do, and we should be doing the same. So I want you to think about that when you've missed something or we're flagging it and we're being a pain about something like that. We're doing it for your protection because we unfortunately see the negative side of when those things are used as loopholes or someone tries to use it to get out of a situation or be difficult, because everything's fine until someone changes their mind or they have a challenge and then they're looking for those mistakes. So just be careful.
It's all fun and games until a missed initial kills a transaction. Is that what that saying is?
Right?
Something like that.
Exactly.
So I'm going to go off script here for a moment, just to say related to that. I talk with a lot of other agents out there in the market as well. Some people, prospective recruits, things like that. We're talking about challenges and that kind of thing. And I'll tell you what. As much as it could be sometimes frustrating, to get that notice that comes back from Skyslope from Kimberly or Shannon here. I can tell you that the legally required broker review out of all places essentially consists of, does the paperwork exist? Oh, it does? Good. Stamped. And then you run into those challenges later. And that's when it's truly painful. So, I mean, just a huge kudos to the fact that, if you're not aware by now, like these ladies actually look at everything that's in the contract. When you've added additional terms, they read the additional terms. And sometimes it's a question of, hey, in Shannon's mind, she's thinking back 12 years to when that same language was used and the intent was this, but the other parties took it as this. That's where some of those questions come from. And the other, kudos I want to give to Shannon here is that, as much as, we do have to be sticklers about some very specific items that are just purely black and white, what I really appreciate is, again, all that breadth of knowledge, working with all of you folks as well, and actually working together through these things, has given her some pretty incredible risk management chops to look at something and say, how much do we actually need to push an issue, right? And occasionally she is able, to find a separate solution for you guys. Like if you're having a real hard problem with the parties on the other side finishing something you need or whatever, she actually has that knowledge to help you all decide together as well, like, hey, does this really need to be an issue, or can we do something different here? So again, you're a little slack if you think, geez, if you find yourself rolling your eyes or whatever, there's probably a lot more to it. And if you're not sure, she's always happy to chat. So kudos to you, Shannon. We appreciate that.
Thank you. Any questions anybody has on any of that or anything you're seeing out there that I can help with, since we've got a few more minutes here? Oh, yes. So the question was, as a broker, do we have access to legal counsel without a fee? We do. AAR provides, they call it the legal hotline. So we're able to call them in situations. I typically will reach out to them for very kind of basic questions, or just interpretation of a contract, because they are probably the ones that were on the committee that wrote the contract, most of them. So they have really good insight as to the intention behind some of the language in the contracts or the addendums and those kind of things. If it goes any deeper or a little bit different, we do have a legal, we have an attorney that helps us otherwise that I go to depending on the situation. So yes, we do. Oscar? Yes. We want to try to back up to that one. And I'll try to find my sheet here. Basically, if it's determined that their equity is going to be between 200 and 250, and there's a judgment lien recorded, right? Regardless of the judgment lien amount, if their equity after paying the first mortgage or whatever it is, and then their reasonable fees to close is between that 2 and 250, the title company then has to send that judgment creditor a notice and allow the judgment creditor to either release it. If they don't respond within the timeframes that are required, then the title company can go ahead and close without paying it. If they come back and say, no, it needs to be paid, which assuming, yes, they do respond. If they do that properly, then at that point, it either has to be paid or the seller would need to contest it through legal proceedings, is my understanding. Cindy? That's okay. I believe it's when it's their primary residence as a person. So I'd have to look up and see. Yes. If you are a person that owns it and it's your primary residence, yes, in Arizona. Right. Yeah. So for those online,
yeah, our very seasoned professionals here are reminding us of
experienced. Are reminding
that's absolutely a very genuine compliment. Okay.
Yes. That back from what we remember, that you had to file for that homestead exemption. It wasn't just automatic. I'll confirm that with Jody or with title and somebody and just make sure if that's changed or not. Because I do remember that, but I don't remember if that's changed over the years. Right. And I think for most people that have that equity of 250 or less, really not going to come into play a whole lot, or even 200 or less, let's say. I foresee that because our values have gone up and people have a better equity position right now, that this potentially could be more of an issue here now with this change. Now that those are automatically attached, essentially, if they're recorded against the owner. So.
Thank you to Cindy for, yes, thank you for saying what needed to be said.
Right, right.
Kim, you had a question, Ollie?
And yes, and they already see that online, I'm assuming. So yes, yes, you can do an amendment, or you can change it on the contract and have everybody initial those changes, just like anything. And I know a lot of that comes up a lot with what has to be reinitialed by both parties. If there's a change to a contract, say you miss a box for the home warranty or for lead paint or something like that, and it's a change to the terms, both parties have to initial that change anytime you're changing it, because you just can't amend a contract arbitrarily. If it's where a seller just missed page 4 initialing the bottom, not necessarily. That's just them re-acknowledging what they already had signed at the end or the other pages. So if that makes sense, it's more if it's a change in terms that affects both parties, that has to be addressed by both and initialed by both. That makes sense. Danielle? Yep. Yeah. I do think that's probably fine, yeah, because it is corrected before it's executed. Yeah. I think so. I'll think about that. Make sure there's, I don't think that affects. It is. Right. I think that's fine because you're doing that, you're inputting that information on behalf of your client and indicating their representation. That's just, I think that's fine. I'm thinking through it as we're talking. Any other questions, you guys? Anything online more, Kim? Nope. Everybody good? All right. I don't know if I have an opinion one way or another. The question was whether or not how I feel about the change in the homestead exemption. I don't know if I have an opinion one way or another. I just think for us, it's going to come into play more. I think that's my only opinion, potentially, because the equity position is different, because people are holding title different than they used to. I mean, I think in my experience, back in the day, we rarely saw, I mean, trusts were typically in your retirement communities or adult communities, that sort of thing was where you saw that more often. And cash, they bought it cash, those kind of things. All of this is changing because the way people are holding title, the way the equity position is, all of that's different, and I think going to affect us a lot more in the future because of that. And keep in mind, I mean, Cindy can attest to this, but things like where the names and those kind of things come into play also is that we had a situation recently, and I don't remember whose it was, but where mom and dad passed away, the kids were the successor trustees, and as they were selling the property, I think I see who it was. As they were selling the property, the HOA charged them that transfer fee and then charged it again to the buyer that way. And it was a big fee. And some of those are $3,000-$4,000. Yeah. And so just that change, and I've heard arguments that, and again, I'm not an attorney, but I've heard arguments that's not a change in ownership. It's just a change in who's signing for the same owner. But I don't know. And they still try to do it. And I've heard you have to send pretty demanding letters to get those kind of things cleaned up so that you're not getting charged that. Things like, and I've never seen this happen, but an owner changes, they own it, they buy the property in their personal, and then they go put it in a trust. That is a change in ownership. And if they have a mortgage, a lot of times that note has terms in it that says that if there's a change in ownership, that they have the right to call it due and payable, like an acceleration clause there. So those kind of things can come into effect. I haven't ever seen that happen, but again, just something to be aware of if you have clients considering those kind of things. Mm-hmm. Right. Right. So the comment for those online was that Cindy was explaining that in Westbrook Village, for example, they see if there is a transfer of ownership, say mom and dad are ill and they want to take care of this ahead of time and they transfer ownership to their, sons, daughters, whoever, to their heirs, then that triggers it. But if it's a transfer of ownership after they're deceased, they don't typically view that as a change. They don't trigger that. I think it depends on the community as what I'm hearing out there, and whether the community just tries to get someone to pay it, because some people may not question it and just do it, So I think that's part of it as well. Any other questions on any of that? We good? All right. Thank you, guys. I appreciate you. It's a new year. Everybody feeling good about 2022? Yay. All right. Thanks, guys. Yeah, made it. Thank you, guys. Have a good month.